how is freedom of speech, freedom of expression guaranteed under the European human rights system? That is what I would like to introduce. My name is Dirk Voorhoof. I'm coming from Europe. I'm teaching at Ghent University and Copenhagen University, and I'm also collaborating with the European Center of Press and Media Freedom. In America, in the United States, you have the First Amendment. Very brief, very robust protection. Congress shall make no law abridging freedom of speech and of the press. In Europe, we need some more words to try to secure, to guarantee the same. Everybody has the right to express, forward and receive information, and the essence is that there cannot be interference by public authorities. But this right is not absolute. We consider using freedom of speech, journalism and media outlets to have some social responsibility. And that's why, according to the second paragraph of the article of the European human rights system that we are talking about, which is Article 10, that this second paragraph contains some possibilities in exceptional cases to restrict, interfere with the right to freedom of expression that need to be prescribed by law. There must be a legitimate aim, and most importantly, it must be necessary in a democratic society. It must be justified why in certain cases that freedom can be restricted. And this, you could say, is the core, the crucial center of the whole debate in Europe. From what moment on does a democracy needs to protect itself against too much speech, against abuse of freedom of expression? I said the European human rights system, that's a European convention. 47 member states are under the obligation to respect this convention. From Russia to Cyprus, from Portugal to Azerbaijan. 850 people are living under the protection of this convention. And this convention, in one of the crucial articles, guarantees freedom of expression and information. What happens if one country is not sufficiently respecting this basic principle as formulated in Article 10 of the Convention, which sometimes is called Europe's First Amendment? What can you do as a citizen, a resident in a country disrespecting your fundamental right of freedom of expression? Well, the success of this European human rights system is that there is a European Court of Human Rights established in Strasbourg, where every individual citizen or organizations can lodge a complaint against the state that allegedly disrespects their freedom of expression, the right of individual petition, and the court will deliver a binding judgment, eventually finding a violation and convicting a state for breach of the convention. What is important to know is that the European Court considers this convention, and specifically Article 10 regarding freedom of speech, as a very dynamic, fundamental right. It is not just in theory that it needs to be respected, it needs to be respected in practice. It needs to be implied in the new developments in society, which is an information society. Over the years, the European Court has found by now 625 violations that happened in different countries of the Council of Europe. What does it say, this figure? It says that in so many cases, the court has created a higher level of protection of the right to freedom of expression and information, because the member states didn't reach the level that the European Court requests them to reach. And why is this important? It is important because the right to express your opinions, your value judgments, to exchange information with others is not just an individual right which is important for the individual. The European Court has emphasized and reiterated that this is a right which is crucial for a democracy. It's the oxygen of democracy. There's no democracy with open debate, and the court went one step further by saying that this right also includes the right to offend, shock, and disturb some part of the population or the government, the authorities. It's also important because we can see that freedom of expression is related to respect for other human rights. If you take, for instance, the list of Reporters Without Borders or Freedom House, with the ranking of the countries with the best respect for press freedom, the highest level of press freedom, and at the bottom of this list you have the usual suspects with the total denial authoritarian states which do not guarantee the freedom of expression. You take that list and you put it next to the list of rankings of countries with gross violations of human rights. You can see a clear, significant correlation. The countries with a high level of press freedom, with a high level of internet freedom, with a high level of freedom of expression are the countries with least breaches of human rights on other domains. While the countries which have no press freedom, they are the countries where these gross violations of human rights happen in terms of torture, disrespect of fair trial, and many other gross violations of human rights. I would say there's even one reason more, apart from the importance for the individual, for democracy, and for other human rights. I think the European Court of Human Rights in recent years has discovered that freedom of expression is a core fundamental right for the survival of this planet. When you look at the goals of the United Nations in terms of sustainability, it refers to transparency and accountability. And that is something that we can see more and more, how freedom of expression, the right to information and transparency can contribute that also in the future our societies are secured to survive because we have institutions which are accountable, we have authorities which are accountable, we have corporate organizations which behave in a way that reflects the basic notions of sustainable development. And I would like to illustrate that with a few examples of cases delivered in recent years by the European Court of Human Rights. I can see 4 different domains in which the court seems to reflect this importance for the future of this planet, of its democracies, and of the people living here, the importance of freedom of expression. The first is that the European Court has expanded the application of Article 10 of the Convention towards a right of access to information, access to public documents. This is not in the text of the Convention, but it seems that the European Court, together with other international institutions, became aware that we have a straightforward necessity to have access to public documents as a basic principle in order to know what is happening in society, in order to be able to react against behavior, malpractices by institutions and organizations, and bring them in line with the values of, again, sustainable development. Second, I see the important decisions and judgments by the European Court, more precisely, where investigative journalism is protected. The fact that the European Court found in some cases violations because investigative journalism had been prosecuted and convicted in a certain country in Europe, that demonstrates that the European Court wants to create a higher level of protection of investigative journalism, precisely because investigative journalism plays such an important role in relation to these notions of transparency and accountability. What happens now these days with the Panama Files is a clear example of the need of strong, elaborated work by investigative journalists. They should not be prosecuted, they should be stimulated, they should be promoted. An environment should be created in which such work can be enabled. And that's a message which also the European Court of Human Rights has been sending out. A third example in this same area is the protection of journalistic sources, which guarantees that investigative journalists and journalism in general can work with information that some people are willing to share with society and to bring under the public eye. If you don't have protection of sources, these sources will not be willing, will be afraid to collaborate, to work together, to deliver information to journalists. And maybe this is one of the strongest points of development and emphasis by the European Court. In 13 judgments over a period of 20 years, the European Court found again and again violations against action taken in member states against journalists to have access, to have insight in their sources. This is to stop, is a clear sign by the European Court of Human Rights, and they have upgraded very clearly that right at a higher level at Europe, because the member states themselves did not sufficiently guarantee this right to protect journalistic sources. For instance, one of the very important additional guarantees the European Court has created to protection of sources is that only by a court order or a decision by an independent authority, such an order to reveal sources can be given. It's not to the police, it's not to public prosecutors to do so, and you can understand that this is a very structural, procedural guarantee in order to protect journalistic sources. A last issue which I think is very important and which illustrates the added value offered by the case law of the European Court in Strasbourg, that is the issue of protection of whistleblowing. There's no reference to protection of sources or whistleblowing in Article 10, but the European Court has felt, being confronted with some cases in this area, that an additional step needed to be taken to protect whistleblowing, because also whistleblowing is to be considered as an important contribution to have more accountability, to have more transparency in what is happening in our society. And many member states were not willing in Europe to afford some level or enough level of protection of whistleblowers. And in several cases last years, the European Court found that the member states, by not protecting whistleblowers, disrespected Article 10 of the European Convention, giving whistleblowers themselves a right to express or to forward information which can be of interest for society. Even in the domain of intelligence and security services, and I would like to emphasize that because we can see it both in the area of protection of journalistic sources, access to information, and whistleblowing. In all these domains, the European Court has recognized that these principles of protection are also applicable when it is regarding documents and informations from intelligence and security services. And this, of course, is an additional step which most national states were not willing spontaneously to accept. And I hope you can understand how important it becomes that there can be an actor who is more independent and sees all the values connected to freedom of speech that I have just referred to, that is able to create this extra layer of protection and these extra factors, elements of application of Article 10 of the Convention. I hope I made clear with these few references how important this Europe's First Amendment, this Article 10 of the European Convention is for the future, that the European Court also in the next years and decades will play this important role to sustain the level of protection it has created and to keep on following developments in order to fulfill its task and to make the human rights system a living instrument that plays a crucial role for this generations and future generations in upholding human rights, the rule of law, and the principles of a genuine democracy. Thank you for your attention.